Unfortunately, here's how it goes. This poor woman gets raped, and she goes in, not only has to be traumatized by giving the report to an officer with a rape test kit at the hospital, then she goes in and she meets with the county attorney, who hears from the defense attorney that if you want to go all the way to a jury trial and convict this guy, we're going to bring up your sexual history, past boyfriends, all sorts of testimony. And then the prosecuting attorney says, well, we don't know if we can really do this. It's no wonder that they either give up or settle for a lesser plea.
The issue of lenient sentencing in rape cases isn't homogeneous. When force and violence are used, when the accused is a stranger, convictions and long prison sentences are much more likely. But that's not the case with acquaintance or date rape. I'm making the distinction not to take away from the pain and suffering of the victim or to make excuses for the rapist's actions, but because it makes a difference in court, where the law of the land is proving guilt beyond a reasonable doubt.
They're really the hardest cases to take in front of a jury and prove. Oftentimes you have one witness for the prosecution, and that would be the victim, and you have another witness, the defense. So it boils down to one person's word against another, and you have to prove beyond a reasonable doubt to 12 strangers that this crime did indeed happen.
It can be harder to get because you have one person saying that it was consensual and then one person says it's not. Now, that doesn't mean you couldn't get a conviction on those facts, but it becomes harder.
You have to prove to the jury that what happened was not consensual, and jurors will oftentimes have a different notion of what consent is compared to what the law says consent is.
You can get varying results. I mean, I've known prosecutors who'd come in, they were hard charging, they're going to try this, they believe in the victim, they tried the case and they lost. And then they, same thing, come back, tried the case and they lost. And they're sort of wondering what's happened, how did this happen? And it's sort of the dynamic of whether or not they've proven their case beyond a reasonable doubt, and they're sort of learning the hard way what that standard actually means. That's the standard we're at. And if we begin to lower that bar, I'm not sure that people are going to be comfortable with that.
So where does that leave us? It comes down to working within the confines of the law, and that tends to mean plea bargains and little to no jail time. And that will be the subject of our second installment tomorrow. In Mankato, Ryan Gustafson, KEYC News 12.